Okay. Hi, everybody. My name is Brigid Wilkinson. I'm the Northeast Region Rep, and over the course of the last couple of months, you've been getting lots of emails with me desperately trying to get you to give me feedback. So I'm sure you all recognize my name attached to the dialogue on licensing. Yay. So, back in May 24, the Law Society put out a consultation paper. This is actually one of the topics where we did get a lot of time to put some submissions together. And we then asked for more time because we wanted to be able to come back to this plenary and talk to you before we put our submissions in. And they said no. And then we realized, well, we've actually spent a couple of plenaries talking about this topic over the last few years. So we figured everybody who really wants to get their opinion to us is going to get their opinion to us, and it happened. So thank you all for doing that. So the way that we decided to reach out to you, we'll go through that, but they requested feedback on 4 options for revamping our licensing system. The first one was don't do anything. Option 1. Option 2 was let's leave it the way it is, but let's improve it. Option 3 was let's get rid of articling and replace it with some better exams. And option 4 was LPP, PPD for all candidates, but with no placements. So you all responded to our survey, so you know what our opinion is. We put together a committee, first of all. At the last plenary, we did do a presentation on this topic, and we said, anybody who's interested, let us know, because we want this to be a wide-reaching community. And you can see we have really good representation on here throughout the province, throughout size of association, size of firm, practice area, all kinds of diversity was on this committee. So we feel like we had a committee that represented the lawyers of Ontario. We also did an online survey, and we got a resounding response. Thank you to everybody who encouraged members of your association to fill that out, because it was a really good response, and it's really nice when you're telling the Law Society this is what we think, that it's 750 people saying what they think. So thank you. Is there anybody from the Law Society here right now? Okay, hi. Our phone-in consultation was not as much of a resounding success, but we did set up 2 phone consultation times where people could call in, and we feel like at that point people felt like they told us everything they needed to tell us. So that's what that was. So in this survey, we gathered quite a lot of very useful information, and this was appended to our submissions to the Law Society. So I know how much everybody likes graphs and charts and percentages, so I thought I'd just roll you through them because you answered the survey, but you didn't see what everybody else thought. So here you go. In what type of practice do you currently work? You can see where most of our respondents are private practice in firms of 2 to 10 lawyers. So small firms responded to this. Where do you currently work? We got rural, small town. Now, since I was the one designing this, what does a small town actually mean? I meant an actual small town. Like not a city, because our city first category is population under 50,000, and we went up from there. So our biggest respondents was city population 100,000 to 500,000. So you can tell the bulk of our respondents are not from Toronto. They're from outside of Toronto. And that's a really good indication of the geographic spread of the people participating in the survey. One of the things we were interested in showing the Law Society is that this getting rid of articling thing isn't going to solve the employment problem. It's just going to get people licensed and then still have the problem of finding a job. And we wanted to show that articling actually helps people find a job, and we thought that that's probably the reality, but here's the survey showing, yes, that is the reality. So for, what's the actual percentage there? For 36.81% of you, your first job as an associate was at the same firm where you did your articles. So that's 36.8 people who didn't have the stress of going and applying for a job after they got called to the bar. And that's a great thing not to have to deal with. So that was a good response. Thanks, guys. And then you've still got a few people who didn't article, people who went through the NCA process, people who went through LPP took the survey as well. If you articled, was your articling experience useful in helping you prepare for the practice of law? We all know that law school trains us about the academic aspects, but what trains you to be a lawyer? Articling. Try to be a lawyer before you're licensed and be thrown out into the world to serve the public. Know that you can actually do it. Know how to run a business. Know how to serve a client before you're allowed to just do that on your own. So yes, you found articling to be very helpful. One of the topics that had come up in the articling process, and one of the reasons to maybe get rid of it, was because of the bad experiences people were having, and the difference between the, sorry, I'm losing my words, but you know, power dynamics, there we go. Because your articling principal has all the power and you're just a student. So we wanted to find out what kind of experiences were people having. And I gotta tell you, the comments on this were hilarious. We're all lawyers, we're all A-type personalities. I got so much flack for the way this question was drafted. There's a lot of people out there who want to be statisticians and analysts, and they wanted to make that question better. But the good thing is, look at what that no is. And it was such a wide-reaching question. Did you experience any harassment, bullying, or extreme hours? And that many people said no. And that was pretty wide-reaching. So if somebody had a bad experience, they were telling us about it, and we had a lot of people having a good experience. Then we wanted to know, would you hire students? What's this perceived bias everybody's talking about? So we had categories. You've hired an articling student, you've hired an IPC or LPP student. Yeah, it's only 3.3% who have hired those, but those programs haven't been around that long. And we didn't ask them when they hired them. So these are people answering this survey who've been hiring students for 60 years. So you would hire an articling student, you would hire an IPC student. So there are people who are interested in both of these streams. And again, with this one, a lot of the comments of people who took the survey were, I'd love to talk about this, but I'm not actually the one who gets to make the decision about whether or not we hire somebody at my firm. So I can't answer, yes, I'd hire somebody, because I don't get to do the hiring. Here's the one that I wanted to know the answer to. Why aren't you hiring a student? It's because it's hard to afford to hire a student. You don't know whether or not a student is going to be able to earn back what you pay them in your firm, and we're all small business owners at the end of the day. So we'd love to help out, we'd love to train the profession, but we're gonna need a little financial support in order to do that, because we're competing with Toronto's firms for what people think that they should get as an articling student. I gotta tell you, I still don't make as much money as I did as an articling student on Bay Street. They make a lot of money. Yes, it paid off my student loans, but when I decided to go work in a small town, I took a pay cut of $45,000 a year, because that's what I wanted to do with my life. But if we want to serve these areas, people have to recognize we're all making that decision. Do you agree that on-the-job training should be mandatory? Yes. So we immediately eliminated both options 3 and 4 in our responses. 93.7% of you said it should be mandatory. You should not be allowed to serve the public until you have served the public under the mentorship of a practicing lawyer. Any other regulated profession, any other trade requires you to apprentice, to do an internship, to learn what the job is before you are given a license to go charge people money for it. Let's not put all of our regulation post-licensing. Every single submission we make to the Law Society says, you guys aren't enforcing your regulations already. So let's stop having conversations about adding more. Let's regulate and enforce what we already have. We can't make licensing something that we enforce later. We've got to make sure people are competent before we let them serve the public. And then we wanted to check out what people thought about the LPP program. And so we said, would you consider a licensing system in which it's mandatory for everybody to do that LPP program to ensure a consistent practical training? We got some pretty positive response. LPP doesn't have the bad reputation people keep saying it has. And I know I'm a mentor in the program myself. There are students taking that by choice, and they're really excited about their training. And I know there's people in this room that took that program, and they've been really well-trained lawyers. So the stigma goes away, which the longer something exists, it goes away. So just give it time. Would you be in favor of reducing the articling term from 10 months to 6 months? No. More training, not less training. And then we were like, well, maybe we can propose to them some other kind of system. If the problem really is that there aren't enough articling positions, maybe we can talk about if you're going to work in public service, for example, maybe you don't have to article because you're not providing services to the public. So we thought we'd ask a couple of questions in that realm to see if we could put together option number 5 for the Law Society, but our survey didn't support that, and we represent our members, so that's why we didn't propose an option number 5, but we tested the waters anyway. And then that was just if you answered yes to the first question. So yeah, our position was no to 3 and 4. You gotta have an on-the-job training aspect of the licensing system. Status quo has some cause for concern, clearly. That's why we're having this conversation. The Law Society has been looking at this for a few years, as it should. Our licensing system should be reviewed, and we should test it and make sure it's still working and still serving the public and still serving our profession. So this is a good conversation to be having. So we went into what we would do to improve our system, option number 2, and I've got the link there for what our submissions on that were. So that's the end of the slides, because who cares that? But we made quite a few suggestions about how to improve the existing system and what we as practicing lawyers need in order to do that. One of them was showing, yes, there are more positions out there. LPP has proved that. IPC has proved that, the integrated practice curriculum. People are willing to train lawyers, but they need financial support to do it. And it's not just in the salaries that we pay students, but it's in incentives for lawyers who provide that training. Let's really beef up CPD programs. Let's help them know how to train somebody. Just because we're a lawyer, I know we all think we're awesome, but we're also small business people. It doesn't make us good teachers. So maybe let's design some programs to help people who sign up to be an articling principal. This is what is expected of you as an articling principal. These are the goals you're going to be expected to meet. Here are some tools to make you good at it. Here are some people who've done it before that can help you do it. And then how do you find the students? If you're in a small firm, you don't have time to be putting up job postings and doing interviews for a bunch of students who may or may not want to come live in your community anyway. And so you're going to need some help. There is an articling registry, but anybody who's gone to any of these dialogue sessions over the time, students don't know these things exist. So we've got to really market the fact that there are ways of the Law Society pairing students. One of the reasons why the LPP has 100% placement is because there's somebody whose job it is to actually find you a placement. The Law Society doesn't do that. I'm not saying they have to, but they could make it a little bit easier to find somebody, to pair students with articling principals. Yeah, that was pretty much our submissions. If you have more questions about anything, I'm happy to talk about it, but we're just waiting for the next step in the process now. Thank you for everybody who went to any of the sessions that we had, answered our survey, went to the focus groups. There has been a good consultation on this, and we just need to continue participating and making sure our voice is heard. Thank you.
So, for the first time in 50 years, I've missed more than one day of work due to illness, but I told my doctor I have to be here, whatever it takes, because you have no idea what a pleasure it is to be amongst my colleagues to discuss paralegals. During the course of the year, at least once a month, I have at our monthly meetings, I have meetings with the benchers. It always includes paralegal benchers. And then during the year, I go to various receptions for newly called paralegals. This is a real exercise in tongue biting and highest forms of civility, because we all know that we're not the same. The Law Society has to treat us the same. They're conflicted. It's the one major area of conflict between this organization and the Law Society. Because although the benchers see the realities, they have the same tongue-biting and civility issues that they have to deal with their paralegal colleagues who are benchers. In any event, I've given you my report. I'm very thankful to have had the support of FOLA and its membership and my colleagues in most of the positions that we've advocated on behalf of lawyers in connection with paralegals. In my report, I did overlook the reference to possible increase in the monetary jurisdiction of the Small Claims Court. I see that as positive, just like I see the proposed amendments, some of the proposed amendments to the criminal code as a mixed blessing, because when you increase the monetary jurisdiction in the Small Claims Court, you make paralegals very uncompetitive. So that the higher you increase it, the more likely lawyers will take on the task of doing a lot of work in the Small Claims Court, which will make it quite obvious what the difference is between the quality of service that litigants in the Small Claim Court will get from a paralegal as opposed to a lawyer. I'm thankful for John's work in connection with the response to the issue of governance in the Law Society. I think we have to be very careful that the proportion of paralegal benchers to lawyer benchers, if there's going to be any change, that proportion be maintained and not increased in favor of paralegals. I also did not refer in my report to the possibility of the paralegal committee in the future expending some money for interpreters where appropriate to interpret non-English media in connection with paralegals who advertise their services to persons whose first language isn't English, to make it appear that they're lawyers. I'm pleased that the Law Society has started to accelerate their discipline proceedings involving paralegals holding themselves out as being able to perform work that is beyond their scope. I don't think they're being penalized appropriately, but that's a different issue. At least something is being done about it, and I'm very pleased to see that the Law Society is doing that. We're in a waiting game as far as the Boncala report is concerned. There seems to be some reluctance by the Law Society to do very much. They've got a busy schedule. The busier they get, the better. It's an election year this year. I can see the process of determining who can provide legal services in family law and what training they need. I can see that postponed for another 2, maybe 3 years. That's all very helpful. Those are really all the comments I have. I hope you've read the report, and I'm open for any questions. And again, I'm very thankful for having held this position for these many years, and proud to say that in my watch, there has not been any increase in the work that paralegals are authorized to do. Thank you.
Thanks. Can we get the clicker, Katie? Sorry. Thank you. Great. Thanks. So at the November 2013 plenary, the presidents unanimously passed a resolution asking the Law Society to establish a working group or committee that included Law Pro to examine the state of real estate practices and problems faced by the real estate bar, with the objective of developing a plan to address identified problems in the long-term interest of the public of Ontario. That committee was struck in 2014, and at each plenary since then, we have reported on the progress of our work, and we are very happy to continue that tradition today. First, I want to welcome Eldon as the new real estate co-chair. Eldon's like the cat who just came back. Like the cat came back the very next day. As the immediate past president, this should be Eldon's last plenary, but he can't get enough of us. And Eldon has graciously agreed to stay on the executive.
We can't get enough of him?
That's true. We can't get enough of him. So he's graciously agreed to stay on as the co-chair of real estate with me. So I left my practice a year and a half ago and went in-house with a title insurer, and there are times when there are conflicts of interest, including the recent submissions to the Law Society on title insurance incentives, and Eldon stepped in and did that. And I've been working with Eldon for the past 5 years on FOLA, on real estate initiatives. So I'm thrilled that Eldon has agreed to stay on, and he's a cat. We're happy that comes back. So the FOLA's Real Estate Committee has been involved in a number of standing committees, and I'm not going to, I was going to say you can just read them, but they need to be actually up on the screen first for you to be able to read them. And then we're going to briefly, Eldon and I are going to talk about the current issues that we've been involved in, including the review of title insurance incentives, a provincial working committee that that's being established, remotely witnessing documents, electronic funds transfer, standard closing documents, yeah, that's okay, local real estate reps, the upcoming venture election, and some other resources.
Okay, so first, thanks, Merredith, and I just want to set the record straight, lest anybody think that we're sharing the workload somewhat equally. If you practice real estate in the province of Ontario, you should have a tiny or a large picture of Merredith on your wall. Because
for darts?
She looks after all of us that do work as real estate solicitors. I'm just there to be the pretty face, I guess.
Yeah.
Well, no, I'm not even that. That was meant to be a backhanded. Never mind.
It's all good.
Anyway, I just want you all to know that, seriously, well, I'm very grateful because Merredith and I have worked on stuff together and we work well together, but we really are fortunate to have Merredith doing all the hard work. There are times, though, as she mentioned, where just her job means that she shouldn't really be involved in certain issues, and one has come up very recently. The Advertising and Fee Arrangements Working Group has been studying whether or not real estate solicitors should be prohibited from receiving any benefits from title insurers, and that could include anything from pens and pencils to free CPD to actual payments for volume to the examining counsel fee that Stewart Title pays to the extra insurance benefit that you get if you use a Title Plus policy. There are a myriad of different benefits that you may receive in your practice if you're dealing with a title insurer. So they've been studying that. We, through our real estate reps, went out and canvassed the province, and I'm happy to say that our final report on this, which I won't go into in any detail, but it is in your materials, basically came back to say to the Law Society, look, real estate solicitors are professionals. Professionals should be governed at a high level and should be given a role to play, and they should exercise their own judgment. You are not to take bribes. You are not to compromise your advice to your client on what title insurer to use, whether to use title insurance at all or not. You're expected to be a professional. That's what the rules say now. There are multiple rules in the rules of professional conduct now which specifically and generally govern us in dealing with these issues. And what's going on is that the Law Society so far, in my respectful submission, isn't enforcing those rules. What they need to do is focus on enforcement, not prohibition. So if I could summarize a very lengthy paper that I would commend to you to take a look at, that's our message on behalf of the Real Estate Bar to the Law Society. The submissions were due October 31st. However, if you have not expressed your opinion and you want to, I would commend you still to send your thoughts in. I don't think any decisions have been made. I can tell you that we did get a significant volume late in the day of submissions from individual lawyers and from associations. And with, I believe, only one exception, they were more or less unanimous in their support of what is the FOLA position. So that's the submissions on title insurance. One of the things that's going on now, and again thanks to Merredith, is she's forming a working group to examine...
No, that's the Provincial Working Group that's forming this subcommittee.
Well,
sorry.
I
Ray Leclerc is heading this up. Don't give me the credit
Okay.
here when Ray's in the room and should be getting credit for this.
They're looking, yeah, sorry, and I apologize, Ray, for that. The OREA, which will be familiar to all of you who are solicitors, the Ontario Real Estate Association, has a myriad of standard clauses that they provide to their realtors for incorporation into their real estate contracts from time to time. This working group is going to look at those clauses and give feedback on those clauses, hopefully help to improve them. Understanding is that the meetings of this group are going to be held by conference call and or by email. So the hope is that there will be a wide geographic participation in this working group. There's been a number of expressions of interest so far, but if you have any interest in that, please contact Ray or Merredith. Let them know that you're interested, and hopefully we, as real estate practitioners, can assist OREA in getting better wording into their contracts, which will cause less grief for us and less issues for our clients.
Yeah. Another issue that we're dealing with is remotely witnessing documents. So technology has really changed the way that we can communicate with clients. And, you know, I know fax machines are the scourge of lawyers, but we still get faxes and are required to send faxes from time to time. But, I mean, clients really today want to be able to communicate by email, by video chat, by various other means. We've received several inquiries about remotely meeting with clients. You know, can lawyers provide legal advice by Skype or by FaceTime? Can they witness a document over a video conference? What about commissioning an affidavit? Can that be done if you're not in the same room, in the same presence, when you're not physically present when it's signed? We've asked the Law Society to provide us some guidance on these issues, and so we're looking forward to continuing working with them on these issues. I don't have any answers for you, I just have questions, but it's one of the issues we are working on. Another issue that we're working on is the electronic transfer of funds, which is really the bane of most real estate lawyers' existence. Electronic registration allowed for the remote closing of transactions. We no longer meet in the registry office and exchange documents and keys and register the documents, but the one key piece that is still missing is secure, timely, irrevocable transfer of funds, and it's a really key piece to the transaction that's missing, and we have been working with the Law Society, working with Law Pro on this. I know the Canadian Payments Association is updating their whole system. It's a slow process. We continue to work on, what I'm here to say is we continue to work on this. We've also asked the Law Society to review the practice guidelines regarding the payment of mortgage funds to discharge, to a seller's lawyer to discharge. These protocols were last updated in 1992, so we thought perhaps some things have changed since then and they should be re-examined.
Standardized closing documents. If you've been coming to Plenary for the last 3 years, you'll have heard this topic before. I won't talk about them too much, except to remind everybody who hasn't heard this before that these documents were originally created, again, by the working group, by Ray and his group, including Merredith. When I became chair, they were there, but there seemed to be a real low percentage of uptake in using them. They help real estate lawyers, in my opinion, and I'll give you one very concrete example in a second. So for the last 3 years, we've been working on promoting them. Ray and Merredith and Ray and I have done some traveling around to promote them. We're slowly gaining, I think, in uptake in the real estate bar, with the exception of the GTA, and we're working on that. They really are helpful, and I would commend them to any of you and commend them to your members. On October 31st, as mentioned earlier, I think it was because my own real estate deal was closing, the TerraView system went down, and you couldn't close a real estate deal that day. For us in my office, who have the standardized closing documents, and particularly something called the delayed closing escrow agreement, it took about 10 minutes to deal with the problems, filled in some forms, sent them to the other side, all of the necessary contractual obligations you get into when you're trying to move somebody into a house they don't own, and somebody else has to insure it, and what you're going to do with keys and money and all those things. It was all there for you to start from. The lawyer I was dealing with in Toronto, who was buying from me, was just mesmerized by this because he'd never heard of it, and was amazed at how much easier it made that day. I am sure that there are many lawyers in the province who don't use them, aren't aware of them, who had complete meltdowns that day, trying to figure out what to do when you couldn't actually register your documents. So I think these are a great thing. They've gotten lots of support, and hopefully we'll keep building that momentum. Associated with that, or in a similar vein, is the three-party DRA, document registration agreement, which I will give Merredith credit again for this. She's been pushing the Law Society on for a long time now, and I think has finally pushed them to the point where they should be, which is there is now this multiple party DRA in place for people to use. I'd commend it to you. It's posted on the Law Society website. You can get it in both PDF and MS Word. And again, when you have that situation, it is a wonderfully helpful tool rather than try and sort it all out yourself and negotiate all the various items that should be in there.
Just before you go on to the next topic, somebody contacted me yesterday to say that the link in my paper wasn't working to the three-party DRA in the report, excuse me. So if you want to, I now have the correct link. I wrote the paper and then put in all the links, and then the Law Society completely revamped their website. So then I redid all of the links, and clearly they have rejiggered their website even further because the new link still didn't work. So I do have the correct link. If anybody is interested, my email is in the report, so you can send it to me. You can ask me for it and I'll get it.
Local real estate reps. A few years back, we decided we needed some specialized real estate contacts in each of your associations. We have a list. We're not so sure that list is up to date. Sometimes we get very good feedback from those local real estate reps when we contact them. Sometimes we don't. So if I can ask you, if you know who your real estate rep is, please make sure we know who it is. If it's changed recently, let us know. We told all of the presidents, if you don't give us a name, then it's you. But quite frankly, if you're a litigator, I don't think that necessarily should be your role. So if we can get those dedicated links, it's very helpful. And as Jay mentioned yesterday, one of the great benefits of this organization is its ability to respond quickly and be nimble. When Jeff Lem came to us last week and needed to get word out on this, needed to get word out on the fees going up, they increased the fees by like $3 per registration. So what? Well, so what is your trust account isn't going to balance when an extra $3 gets taken out that you didn't know was coming out on all these deals. And so we became the conduit to try and get the message out. And I think did a very good job, but we can do a better job, and we can do a better job if we have that up-to-date real estate contact list. So please let us know.
Kelly Lovell is the keeper of this list, so if you're not sure who we have as your local real estate rep, check with Kelly. She has the list here with her today. She'll let you know who we have on the list, and if it's not that person, you can update it. Very quickly before we finish, you're probably aware that the Bencher election is coming up in May. Nominations are currently open. They close on February 8th. Anytime I'm given a microphone, I always talk about the Bencher election, and I have been talking about it since well, since the last election concluded. And it's something that I feel very strongly about. As a solicitor, it's always disappointing to me that solicitors seem to be notoriously underrepresented in our governing bodies. Out of the 48 elected lawyer benchers that we currently have, 3 have real estate experience. I undertook a campaign in the last election to encourage more solicitors to run, to encourage those solicitors who were running to get votes. We're going to be doing the same thing again. I know I'm thrilled that there are a number of people in this room who are putting their name forward or who have already put their name forward, and I think that's fantastic. We need engaged benchers. I think it's important. If you're interested, if somebody in your association is interested, and there's anything that we at FOLA can do to assist, then by all means let us know. Finally, in our materials, there's a number of websites that are listed that are I think very helpful real estate resources, and I encourage you to share those with any of the real estate lawyers in your associations. Thanks very much.